All right, and then we've got Brendan Mahatoo, Mahatoo, and he's a lawyer. And I'm going to hand over the mic to him. Do you have any slides up here? No, but you got some handouts. Okay.
Hey everyone, my name is Brendan Mahatoo. I'm a real estate lawyer. I'm also one that's probably going to start sweating profusely because I'm wearing a suit and a jacket and a vest. But that's okay. So the handout that's kind of coming out is going to be talking about an issue that came up towards the end of last week. I've had it happen before, but it happened towards the end of last week, and I'm dealing with it this Monday, so I thought it would be a great one to write about since it was pretty salient. Quick bit of background on myself. Sorry if anyone's heard it before. I probably say this all the time, but yeah, I really love real estate. Being a real estate lawyer was my dream since I was 5 years old. So I'm just living the dream now. It's fantastic. I have a pretty volume-based practice. I do a lot of transactions. I have a good amount of experience. I'm very proud of the amount of deals I've done and the work that I do, and I'm incredibly proud of the client-focused approach that I bring, which is great for if you're buying your first home for your family, or if you're buying real estate too as an investment or business acquisition. So the handout that's going around here today is on powers of attorney or estates in relation to what's called lawyer's approval and a standard offer to purchase. I'm starting to recommend to people when I do private deals for them where I do their offer to purchase for them to, make sure going forward if they get a realtor or whatever it is, that they put in a clause for a lawyer's approval when they're on the buyer's side to sort of protect themselves if the seller is, you can do a lawyer's approval for a number of things, but particularly for today, so I'm not standing here for 45 hours, is to sort of protect yourself to make sure that your deal is actually going to work the way that you want it to in relation to a power of attorney or an estate. So I'll give you one example in terms of estates. Well, someone's passed away, their executor's selling their property, they put in an offer, it's accepted. All of a sudden it's discovered that, well, the estate hasn't actually been probated in full, or there's an issue, and then possession days have to be moved and stuff like that. So if you're ever buying an estate sale property, it's always a decent idea to put in a clause for lawyer's approval so I can check on the court registry or check on whoever's probating the estate and make sure that it's going to come along in a time that's actually going to work for your possession day, or if you have financing and stuff like that. And then the power of attorney issue is one that comes up all the time because, well, there's a lot of good lawyers out there, there's a lot of bad lawyers out there, there's a lot of people who've drawn up their own powers of attorney to whatever effect they will have. So using a power of attorney, someone might be using a power of attorney to sell their property because they're in Denmark traveling and they're not going to be there for the possession day, so they're going to get their friend or their brother or their parent or their cousin to sign on their behalf. That's totally fine. You might be using a power of attorney because the registered owner of the property is incapacitated or has been deemed incompetent. So if you see that your seller is going to be selling through power of attorney, great idea to put in a lawyer's approval clause because, well, I have a very difficult situation right now where the power of attorney, I didn't receive it until the offer was firm. No lawyer ever reviewed it. It took me about all of 35 seconds to realize that this power of attorney is not going to work at all for the sale, and so the contract's frustrated. And now, well, it's a bit of a mess because the person who drew it up is incompetent now, so they can't now make power of attorney, so we're in a bit of a sticky situation where someone's going to have to go through a much more complicated legal process. So I'll say that my client, who's a purchaser, is really disappointed at this point and probably not going to be able to move forward on that deal. But if you put in a clause for lawyer's approval and it comes to me or another competent real estate lawyer, I can't imagine there are other ones other than myself. Just saying, but no, more to the point. I can take a look at your offer. I'll see, okay, this is being signed by power of attorney. I'll say to the realtor, whoever has it for the seller, the seller's representative, let me take a look at it, make sure it's going to meet the requirements of the Manitoba Land Titles Office, because, well, those people go through those things with a fine-tooth comb. And I'll say that I make very good powers of attorney. They go through the Land Titles Office all the time. I've had lawyers, powers of attorneys, and they're lawyers who have been practicing for a very, very long time in estate law, but they haven't really kept up to date on what's required for a power of attorney in relation to a real estate transaction, and so I'll see that Land Titles definitely will not accept it. And I've had that happen because of many years, not that many, but a good amount of years of experience in a number of transactions that have been signed by powers of attorney. They're pretty common nowadays, in particular to the very international world that we live in. Numerous clients of mine have made a power of attorney so that they could go back to their country of origin or travel and be able to have their parents or other representatives sign on their behalf. But I've also seen the very complicated side of things when the power of attorney fails going through in a transaction. I'll give it for instance where it was my own mistake, and I love owning up to my own mistakes because I always try to fix them, and I've been very lucky that I've been able to fix mistakes that I've made. I reviewed a power of attorney and I believed it to be effective. I still believe by law it's effective, but I'm not really going to sue the Manitoba Land Titles Office over annoying me through rejecting a power of attorney. I should, and I did spend about a 45-minute session of arguing back and forth with a register at the Land Titles Office, talking about how power of attorney met the requirements of the legislation, but apparently someone who's not a lawyer decided that it doesn't. So anyways, it was rejected, and so it was a massive problem for my client because they were selling their property. Very, very luckily, the person who gave the power of attorney was competent enough to still sign a transfer of land, so I was able to do it that way, but that could have really blown things up, and so that's why I recommend to many people and get a lawyer's approval if there's a power of attorney involved, because they can be a bloody mess if they don't work. That's pretty much my kind of go-to thing for today, so if you have any questions, let me know, and feel free to grab some more of my brochures. I'll get some more out and I'll put them downstairs or something like that. So, yeah, great, thanks.